Okay? So I just I've given you some basic information about it, about the decisions that were made to go forward with the Dakota Access Pipeline and to move the route of the pipeline from 10 miles north of the 92% white community of Bismarck to down within 250 yards of the 82% Native American Standing Rock Sioux Reservation. But what I want to do now is I want to detail for you, without boring you to death on this, but just to show you the lengths to which we have all gone inside the legal structures to protect the environment against this elite oil corporate group and the comparative ineffectual results of this. Thereby, just so I'll foreshadow this, opening on to the question of what additional actions are merited now in light of the ineffectiveness of seeking the legal redress here. First of all, there was a major lawsuit that was filed by the Standing Rock Sioux Reservation Tribal Council and joined in by the Cheyenne River Tribal Council in Washington, D.C., in the Federal District Court in the District of Columbia, asking to have the pipeline construction stopped because it was in violation of the Environmental Protection Act. You'll remember I pointed out that they were going forward without any application of doing these like 499 yard extensions of the pipeline under this exception to the Environmental Protection Act, that if you just want to build a pipeline from your house down to your boathouse or something that's less than 500 yards, you don't have to ask for environmental protection or environmental assessment. Okay? And so they kept doing this over and over and over again. And so that the tribe, once they realized that they were heading on down to where the Standing Rock Sioux Reservation is and getting ready to go under their sole source of drinking water in Lake Oahe, that they filed this action in Washington, D.C. The case was assigned to Judge Boasberg. Judge Boasberg in the Washington, D.C. District Court is a member of the William Bennett Williams Legal Lodge. It's a private fraternity for lawyers. And there are these various types of political and professional associations that lawyers join or don't join. But this particular one, the William Bennett Williams Legal Lodge, is in fact a private fraternity of men who are all criminal defense attorneys for corporate criminals. That's what they do. They like to refer to it as white-collar crime, as distinct from blue-collar crime or no-collar crime. Boasberg is in fact a long servant of the corporate criminal interests. And he got this particular case, and he demonstrated over and over again that he was flagrantly biased on behalf of allowing this pipeline to go forward. So in Earth Justice are the ones that represented the tribal council, the Standing Rock Sioux Council, and they first applied for a temporary restraining order. So look at on the face of it, this flagrantly violates the Environmental Protection Act. That not only did they do this nitpicky 499 yard thing without any environmental assessment in violation of the Equal Protection Act, of the Environmental Protection Act, but the fact of the matter is they identified a zone of impact for the oil pipeline, which came right down to within 250 feet of the Standing Rock Sioux Reservation, and they designated as the potential adverse impact area the entire area from that point northward, even though it was on the river flowing southward. And that they said that the zone of impact, therefore, didn't have any Indians in it and didn't have any racial minorities in it. And therefore, there wasn't any problem with going forward with this. I mean, it was like a Trump argument. which is, on the face of it, completely hysterically crazy. But the fact that they put it down on paper caused even Judge Boasberg said he found it very hard to believe that was done in good faith. Okay, but it didn't make any difference to him. And so he denied the temporary restraining order. And he said, and therefore, they're going to be allowed to continue going forward with their construction while I'm trying to determine whether or not this has to meet the requirements of the Environmental Protection Act. And he said, I'm willing to take briefs. I'm going to give the pipeline 2 months to file their briefs. I'm going to give the defense, another 2 months to file their reply. So he's basically giving them 2-month chunks of being able to continue going forward apace, building this pipeline without any type of oversight or supervision at all. And so what we did is the Red Warriors camp and the Ocheti-Socoan camp and later on the Last Child camp, they all began to take actions to deploy against this pipeline, saying that, look, that's why I never recommend to Native people that they invoke the white courts. I don't ever trust white people. They're going to do what they've done to you for the last 200 years. So don't come to me asking me to litigate, against them, because it's crazy. But when they come forward and arrest your people, then you've got to fight back inside the courts. So that's what we were doing. And so I represented Chase Iron Eyes, the 2016 National Democratic Party nominee for the single seat in Congress, in the House of Representatives, from the state of North Dakota, because he was, as I mentioned Tuesday, he was designated by the Tiger Swan Private Military Corporation as the instigator of the insurrection against the state of North Dakota and against the Dakota Access Pipeline. And that they were using this language all the time. The Dakota Access Pipeline Corporation people, the Tiger Swan Private Military Corporation people, and the sheriffs, who had all of their talking points written up for them by a professional PR firm called Off the Record Public Relations, headed up by this guy named Mark Feifel, who, as I mentioned to you, was the same guy that ran the public relations campaign on behalf of George W. Bush in favor of weapons of mass destruction in Iraq to justify the invasion and occupation of the Middle Eastern oil fields. And so that this operation that was going on against the Native people resulted in them being arrested. And Chase was arrested and charged with instigating a riot, an insurrection against the authority of the state and against the Dakota Access Pipeline. And he was also charged with felony trespass on property that had been purportedly purchased by the Dakota Access Pipeline Corporation away from a person who had ostensibly purchased it, in effect, from the U.S. government. And we pointed out a series of things in our defense, which I just want to get out in front of you so you know what the nature of the confrontation was. Number one, we pointed out that it was impossible for Chase and the other 24 Lakota people that were arrested at the Last Child's camp, it was impossible for them to be engaged in felony trespass because it was their land. And that the pipeline, there's a statute on the books in North Dakota saying that a corporation that is not engaged in agriculture cannot purchase any land in North Dakota, or any agricultural land, which is what they designated this high desert prairie the high plains prairie. So number one, they were in complete violation of a black and white statute on the books prohibiting them from purchasing such a piece of property. Secondly, the person from whom they bought it, allegedly, had derived his title from the United States government, who had sold the original landowner the title to the land, in the United States government never had any title to the land. Even under their most forward-leaning theory of how they took land away, they had never, in fact, done anything to take this particular land away. It was never ceded under any treaty to the United States government. It was never seized by the United States government under any of its various attempts to do so. And it was just set there as this unique area of land that, lo and behold, continued to belong to the people of the Seven Council Fires. And so we asserted that to the court, leaving the court kind of standing there like a deer in the headlights, about, whoa, wow, what are the implications of this, right? And then secondly, we said with regard to the insurrection charge or the inciting of a riot against the state in the pipeline, we asserted a thing that's called the necessity defense. That we argued and had all of the historical common law citings in support for this, that there is a doctrine at law that if in fact the classic example is if you're standing along the highway and a 2-year-old wanders out into the highway and there's a big 18-wheel tractor trailer truck bearing down on the child, and you rush out into the highway and snatch the 2-year-old up and get her out of the way of this tractor trailer truck and save her life, and then you're charged with jaywalking. When you come into court, you can put on the defense to show that it was necessary for you to violate that far lesser offense of jaywalking in order to accomplish the greater good of saving the life of this child. Just on the face of it, what does that take? A political IQ of about 4, to understand the legitimacy of that argument. So that doctrine exists. And so what we argued is that Chase Iron Eyes and his fellow Lakota people that were on this particular piece of land, aside from the fact that it belonged to them, that the fact of the matter is they couldn't be charged with rioting when the sheriff's department came up onto the land and tried to drag them off the land. What they did is they charged them under the rioting statute with engaging in violence against the police when the police grabbed them and tried to drag them away because they held back against them. And that was their theory of what the violence was. And they actually stood up and said, well, the standard that we're going to apply under the statute of whether they were engaged in violence is the same standard that we apply, and they kind of smiled at us when it said, in domestic violence cases. I mean, it almost made you puke when you were in the courtroom to hear them do something like that. Because, all they're doing is throwing right up in our face, all the years of work that's been done to protect women against violence on the part of men, even that kind of violence of shoving them or yanking them around like that. And so what they did is they invoked that standard for violence, and that when the police came up onto the land and yanked them, our people all joined arms like this, locked arms, and the police had to pull them away from each other like this. And when they did that, anybody who held back against them like that, or anybody who helped in the chain hold back against them, was charged with violence, was charged with rioting. Okay? And so that we pointed out that for the sake of argument, let's assume that they did pull back. Okay? But that's all they did. And that what we argued is that under the necessity defense, if in fact you find it necessary to violate some particular lesser statute in order to effectuate a much clearer, greater good, that as long as the violation of law that you commit is proportional to what was necessary in order to effectuate your better objective, that you cannot be criminally prosecuted for this. We agree that the burden is on us to establish that, but we were saying, oh, please don't throw me into that briar patch. We were saying, please, give me a jury and let me put this evidence in front of the jury and see what they think about this kind of ridiculous charge, right? And so that what we argued is that the reasons why it was necessary for Chase Iron Eyes and his fellow Lakota people that were up at the last child camp on that day of February 1st of 2017, that why it was necessary for them to go up there on that hill and do what they were doing was because the building of this pipeline, number one, the building of this pipeline directly under their sole source of fresh drinking water was in fact an existential threat to the drinking water of the people of the entire tribe. And therefore, it was in fact an existential threat to the very tribe itself. Because if they didn't have any fresh drinking water, they wouldn't be able to continue to live there. And they would have to move away. And if they moved away from their indigenous homeland, that was instrumental and integral to their identity as a people, because this is the land on which they have been raised and of which they're a part of, okay, spiritually. And so we said this was an existential threat, this pipeline, because we pointed out that the pipeline people were in fact lying to the public, lying to the people, when they said that this pipeline presented no significant threat to the water. We proved that, in fact, the safety system, the detection system that they had on this pipeline, which put 91,000 gallons an hour of oil through that pipeline, was completely incapable of even recognizing a leak in the pipeline of below 1%. And so if there was a 1% leak in the pipeline of 91,000 gallons an hour, they could be leaking 9,000 gallons of oil into the lake every single hour, and they wouldn't even know it. You know, not only that, but they didn't even take steps to be able to detect it. Okay? And so we pointed out time after time after time that this pipeline did in fact constitute an existential threat, not only to the water, but to the future existence of the tribe. And so therefore, faced with an existential threat to their tribal existence, the taking of the limited action that they took of pulling away from the police when they came onto their land to try to drag them away was in fact a minimal necessity that they had to engage in order to effectuate the greater good of attempting to protect their water by reaching out to the people of the country on television and showing this demonstration on top of the hill so people could pay attention to what was going on. Because they had already, we pointed out, succeeded in getting the Obama administration to issue an order stopping the construction of the pipeline on the grounds that it was in violation of the Environmental Protection Act. So it wasn't as though this were a futile effort on their part, because they had succeeded previously in doing exactly what it is they said they were up there trying to do. So that's number one. The second arm of our necessity defense was that what they were doing was protecting themselves against an ongoing federal criminal civil rights conspiracy. What we showed is that the oil corporation and the pipeline corporation had intentionally and knowingly moved the planned route of the pipeline 10 miles north of the 92% white community of Bismarck, down to 250 feet north of the boundary of the 82% Lakota reservation, that they had done that specifically because of the race of the people, that they were doing it there, and it was a complete violation of the 1964 Federal Civil Rights Act. There are specific provisions of it that make it unlawful for any United States agency, such as the U.S. Corps of Engineers, U.S. Army Corps of Engineers, to issue a license to the building of any dangerous or potentially noxious infrastructure anywhere on or near the property of a racial minority community. And why did they have that regulation? Because that's what they do all the time. That's what they were doing all of the time. You know, you can show that like 90% of the time, these big corporations would build these, smut plants and refuge dumps and, sewage plants, all right in the middle of racial minority communities. Okay, and so the Clinton administration in 1997 issued an executive order stating that prohibiting any federal agency or any state agency or any private company that gets any funds from the federal government to engage in building a potentially noxious infrastructure anywhere on or near land of a racial minority community. And we pointed out that the reason they did this, and we found it inside their own documents, that they had done it because of the opposition of the stakeholders from the Bismarck community, And so we put together all of this evidence and information, and we put it together to prepare to file to the court, because you have to show them what documents you're going to be putting in trial, so you have to get them marked as exhibits, and you have to show a legal memorandum as to why it's admissible in court and all of that. And so that we were pointing out that this decision on their part to move that pipeline from the 92% white community of Bismarck down to the 82% community of the Native American people was undertaken, motivated by a class-based, invidious, racially discriminatory animus against Native American people. And anybody who was ever in the state of North Dakota knows that's true. They know that the 92% white community there, almost all of them, harbor this type of an animus against Native American people. It's like being in Mississippi and deciding whether or not the white people are racist, and that we could point this. Of course, we had to go to the lengths of pointing it out with evidence, because the judge isn't going to sit there and just say, okay, I believe you. No matter how obvious it is, it could be as obvious as an elephant sitting in the middle of your living room, but they're not going to acknowledge it. So we dug in and found the documents that showed that the head of the Dakota Access Pipeline, in fact, there were complaints on the part of the members of the U.S. Army Corps of Engineers saying, this guy, Joey, what was the guy's last name? Joey something or other. Anyway, this guy, Joey, who is the head of the pipeline thing, he better stop making all of these racist remarks about Native American people, or he's going to blow the whole thing for us here. We're going to lose our right to do the pipeline. And we got access to that information. And we issued subpoenas for the people that were saying it. They were filing those kind of complaints against him. And we filed a subpoena to take his deposition itself. Okay? And so that we went right down inside and we subpoenaed the records of the Dakota Access Pipeline. We subpoenaed the records of the home companies to ascertain what type of a record they had under the EEOC, the Equal Employment Opportunities Commission, of any kind of complaints ever filed against them for racial bias. And we demanded to have access to those documents. These people were hysterical over the fact that we were getting in their face like that. They thought they were going to be able to walk right over the top of these indigenous people. So that we got in there and we were playing an extraordinarily sophisticated game of chess against them, using all of their own rules, right? And we got right down into their chest on this thing. It had the subpoenas issued. We had access to these documents. We were showing them to the court. And so that we said that not only does such a conspiracy undertaken on the part of the executives with each other to move this pipeline for racial reasons like this, not only does it violate Title 42, Section 1985, subsection 3 of the Federal Civil Rights Act, but it also violates Title 18, Section 241 of the Federal Criminal Code, in that this is a federal criminal conspiracy that was being undertaken by the executives of the Dakota Access Pipeline and the Energy Transfer Partners executives, charging them personally with federal criminal conspiracy. And I mean, they almost crapped when they saw this. When we filed this on them, because they said, "Why, who would dare say that about us?" And I said, "We would dare say it. We would dare say it because it's true." And so that we put that in there, and so they knew all of a sudden they were not the ones on the offensive here. That there was a counter offense being mounted against them. That they thought they were getting away with a lot by getting the local district attorney to charge, Chase Iron Eyes and the other Lakota people with, trespassing, you know? And so here we were sticking them in the face, charging them with federal felonies, you know, that should put them in prison for 10 years, you know? And so the bottom line is, I don't mean to get excited about this, but the fact is this was very exciting. And so we had that laid out against them. And then in a third grounds for this, we said, look, what happened here is when the Dakota Access Pipeline Corporation realized that we were winning, actually, what they did is they reached out and hired the Tiger Swan Private Military Corporation to come in and substitute for their local security people. You know, and I've talked about Tiger Swan to you in the past. You know what that thing is. It's a spin-off of Blackwater International. Blackwater International, in turn, was a function of a major study that was done by the Halliburton Corporation under the CEO-ship of Dick Cheney, in between his service as the Secretary of Defense for George Bush Sr. and his service as the acting president during the W. Bush administration. That he was the CEO of Halliburton. They financed a big study advocating the creation of private military corporations so that they could be hired directly by the oil corporations in the Middle East, and they would be immunized against the same kind of restrictions that would apply to U.S. military forces. For example, the Geneva Conventions, you know. and so that this Tiger Swan group had been spun off from Blackwater International, headed up by Eric Prince, a very close family friend of Vice President Pence, and the brother of DeVos, who is the Secretary of Education.
I just wanted to make sure that we got a couple minutes to talk about the final paper before the end of class.
Okay, we'll talk about the final paper before the end of class. Remind me to get back to that. But here we are. I appreciate that, John, really. And so what we did is we pointed out that the Tiger Swan Private Military Corporation, once they came on site, began racially profiling the Lakota people, calling them anti-Christian, anti-capitalist, religiously driven, indigenous jihadist terrorists. And we got at their internal sit-reps, their situation reports that they were writing up for each other and preparing. And we got access to people who'd been inside their meetings. We found out that they had come in and they immediately commandeered a whole hangar at the airport and set up a whole battle station there. And every single evening they would hold this order of battle meeting. And they would bring in the sheriffs and the state police people and all the private security companies, and they would strut back and forth in full battle regalia, full body armor with M16s hanging around their neck and full battle gear, and be, talking about how to arrange the battlefield the next day, and what kind of offensive actions they were going to be taking, what the enemy was going to be doing. They had imported the entire set of protocols that they had developed in the Middle East, occupying the Middle Eastern oil fields against the tribal people, the indigenous people of those areas, and they'd imported it into the United States. And that's what they were doing. And we pointed out that type of racial profiling of the Lakota people was also a violation of the Federal Criminal Civil Rights Act, the same statute that the oil corporation had been violating when they moved the pipeline, and that they were doing this. And then next to finally, we pointed out that when they went out and solicited the participation of the sheriff's department people and the state police and the others to participate in this conspiracy against the Lakota people, that had transformed that theretofore purely private anti-civil rights conspiracy, racially motivated on the part of the pipeline company in Tiger Swan. It translated and transformed that conspiracy into a state conspiracy, which isn't restricted to just racial motive, but they were motivated now against all of the people, Lakota people and white people and other people from other nationalities that were all there because of their exercise of their First Amendment rights. And that became a federal criminal conspiracy against the state officials, which we charged them with. And then finally, in closing, so we can get to the papers, finally we charged them with the necessity defense because they were knowingly and willfully engaged in inflicting global climate change on the people of the world. And that this was a criminal, felonious act destroying the climate of the world. And when that came in, the judge almost fell off the bench, going, whoa, wait a second, what the hell is going on in this little courtroom up in Bismarck, North Dakota? And we said, well, you started it. You know, you're the ones that arrested the people here, okay? And so that's what was going on, but I hasten to point out that it still didn't work. Because what happened is once they saw all the evidence that we had, they simply dismissed all the charges. Okay? So what we're doing over at our shop, over at the Romero Institute, is we're putting together videotaped interviews of all of the different witnesses that we were going to be presenting, and we're putting together a documentary of what their testimony would have looked like so that we can put it on and put it up on the internet. So tell them, you can't get away with this even by dismissing the charges against us. Okay, so that's what we're doing, but the bottom line is to understand is that it didn't stop the pipeline from going through. Because Boasberg let it keep on going, even though he finally ended up saying, yes, it was illegal, what they were doing. Let's give them a chance to remedy it by preparing an environmental assessment now. And that's all they have to do, and we'll let them go forward. So it leads to the fundamental question is if this degree of work within the legal system doesn't work to stop them from destroying the environment, what's necessary now? So under the necessity defense, what is in fact the proportional degree of violation of technical statutes that can be undertaken ethically and within the fundamental concepts of common law that authorize you to engage in that type of activity to prevent this grievous harm? Okay, so that's where we'll leave it. We have two more meetings next week, Tuesday and Thursday. What I want you to do, I haven't seen all the prompts yet, but I should have, but I haven't. There are no prompts for see, no wonder I hadn't seen them. That was close. Okay, so look at what I want us to do is we're going to be discussing this in the next two classes. You know, we've laid out an awful lot here for you. You know about the details of global climate change. You know the seriousness of it. You know the action going on every night on the mainline news now about the impeachment. You know that now Mueller has even raised the question about the potential impeachability of Trump based on the fact that he's doing nothing to protect our people against an attack by a foreign power on our entire electoral process. And so there's this additional thing in front of us here about the potential impeachability of Donald Trump on the grounds of his intentionally and willfully inflicting massive damage upon the people of the world through global climate change. Whether it's for personal emoluments of him wanting to get a portion of the oil company in Russia or not. Now, if we can establish that, and I've got meetings going on tomorrow and the next day to see if we've got the goods on them yet on this, that if we can get the goods on them, we can sink them like an anchor, and we'll know what to do with all that evidence. But even if we don't yet get that information, the fact is we know he's doing it. And it wouldn't necessarily have to be for his own personal enrichment. It's just for the absolute failure of his oath of office to protect the people and to protect the people of the world. Okay? So that I want to talk about this with you over the next two gatherings that we have, because I want you to start coming forward telling me about, all things considered. What is it that you plan to do? What do you plan to do about this? Has this course had any impact on you to change what it was that you were planning to do before this? What role do you think you play in your generation to try to stop this from happening? Do you not believe it? Do you don't believe that the global climate change is as serious as all the scientists say that it is? And do you not believe that it's legitimate to impeach a person who fails so grossly to protect our people? Or do you just think that, because you're part of the class of people that benefit from the oil, and it isn't exactly killing you right now, that you've got better things to do. You know, I want to know about this, and so that we'll talk about this on Tuesday, and then do a final discussion of it on Thursday to get you ready, because I'm going to go around again and asking you what it is that you want to talk about in your paper under that theme of what is it you plan to do, or what has changed in your plans because of the course. Okay? So there we are. Thank you for coming.